think that we are really just at the beginning, because even for the misclassification, as far as I understand, for example, there is no mention of changing in classes. It's just the adding in the alphabetical order, even though some discussions were about whether we are so far in this new technology that maybe classes should be added. It's not, in my understanding, a general opinion that this shall be done. The second thing is, we see it here in our court that we are just at the beginning. The cases will simply start to come, and they will be coming in big numbers. I think there are some global analyses that in 2026, some 25% of people will be staying at least 1 hour per day on metaverse. I know that as you had the declaration on the future of internet, for example, as a treaty where the European Union, the US was discussing the future of internet, we are not far away of having a thought that this might have some specific bullets, like for metaverse or some other things. Yeah.
So lots of issues, and I think everyone agrees for the time being, it's going to be some fallback positions, like on the personal side, it's going to be judge-made law a lot. And in my opinion, also somebody mentioned it earlier, until we have specified laws and sort of amendments to those laws, I feel like unfair competition is going to play an outsized role in the future in some of these cases, as long as we cannot define the quality of rights and the scope of protection in the new technologies. This is going to be a big fallback option in many countries. The real cases where brand owners are now taking action, let's say the Meta Birkin case or the Nike case or other cases that are coming to the surface now, they are raising these issues sometimes with intermediary courts that don't have much experience in IP cases. And so the question is, what quality are these decisions going to have, and how are they going to be enforceable? And I think that's sort of an immediate concern that, let's say, intellectual capacity and like academic discussions will not solve.
Yes, you're right. I think, as you rightly put it, collaboration and communication are needed across the jurisdiction to avoid the conflicts that we are foreseeing in the very near future. And this is absolutely essential to ensure that business can happen all over the world. It's not just protection of IPR rights. People will not know how to conduct their businesses in the near future. That will be a big problem. And so therefore, the solution is only on agreeing on some minimum cross-jurisdictional standards. Now, how will that be achieved is a difficult question to answer. It can be done by various ways, by having FTAs or some convention on IPR, international convention on IPR. So that's the only way forward as of now.
Yes, and if I may, I would also agree on the point that we see on some examples that maybe the regional approach might not always be sufficient, because if you take the DSA, DMA, which is currently in Europe, you probably also know that there were some American companies which decided not to market a certain new product for the social medias, not being assured of having, let's say, all the details already as the European law expects that. And it might happen also if there is a regional legislation for metaverse. So that's really something where the global approach would be probably indispensable, because how can you have a metaverse company which will, I think now, of any of the 150 already existing metaverse company, which will have to deal with all the laws globally? There is such a difficulty to be in every detail. Maybe you will not be able to do it. So we will see.